Hmm. Hello, am I audible? Hello students, so we are continuing our lecture on the on Indian polity, and this will be the 8th lecture, and this is important lecture as far as we have to understand the fundamental right. Article 21, we have already studied Article 20 in the last lecture. Article 20 talks about 3 important issues: ex post facto law, self incrimination, and double jeopardy. And how Article 20, Article 21 and Article 22 form a group of right to freedom of a person. We have already seen rights being given on different categories. One of them is the right to equality, another of them is the right to freedom under Article 19, and several reasonable restrictions mentioned from clause number 2 to clause number 6. Then we have another set of rights, and these are a new set of right: Article 20, 21 and 22. These are called right to freedom of a person. So what we are going to see, we have already seen Article 20 and how ex post facto law are abhorrent, unconstitutional and invalid, that if any law is made in the previous date will not be valid. Double jeopardy, the person shall not be punished for the same crime twice. Self incrimination, you cannot be made a witness against yourself. We have already seen this. Now we are going to come on Article 21. You must have studied Article 21 somewhere. It says protection of life and liberty. Protection of what? Life and liberty. Protection of life and liberty. These two terms go hand in hand. If your liberty is threatened, your life may also be threatened. If you are put into jail on wrong terms, if you have been there and your liberty has been compromised, there is a possibility your life can also be compromised. So things go hand in hand. That's why it includes both life and liberty. And it is given against the state. Article 21 is against the state. If a state is taking your liberty away or your life away, then you can approach the court under Article 32, under Article 226. But this is one of the major, most important fundamental right, and its scope has grown so big that it includes practically everything. Now, if you see, you must have seen DJs and you must have seen those loudspeakers on temples and other religious places. Supreme Court have came up with a judgment where it is saying that the decibel limits, the amount of voice, the volumes has to decrease. Certain decibel limit is fixed by the Supreme Court and you cannot play beyond that. Even the horns in your vehicle, the voices needs to decrease. Why? Because every time if somebody is honking and you live nearby the road, your life will become miserable. So when it talks about life, it talks about liberty. It also says that the life and liberty is not just living. It's a respectful life and respectful liberty. So to have a respectful life and authentic life, you need to have an authentic environment. So environmental protection is also covered under Article 21. Noise pollution is also covered under Article 21. Water pollution, for a good life you need to have clean drinking water, that is also covered under Article 21. So Supreme Court in its several judgment and many more interpretations have increased the area and the wideness of Article 21 to mammoth level. If you see now, Article 21 has become the most widely talked article in the whole fundamental rights scheme. Right to life and personal liberty practically involves everything. Right to equality also, right to freedom also. And there is a very good judgment where it says that these are not islands which you can deal separately with. This is Article 14, this is Article 19, this is Article 21. They are not separate islands but are interconnected with each other. They are interconnected with each other. They have connections with each other. We will see how they are connected with each other in this class. Along with it, we will see the position on Article 21 from 1950 to 1977 and what changes has came in 1977 in the Maneka Gandhi case. And in 1950, A.K. Gopalan case was a very important case as far as Article 21 go, because it has in some or the other way delinked Article 19 with Article 21, and it said that they are mutually exclusive and they are not dependent on each other. So for a very long time, since the inception of our constitution till 1977, Article 21 was lying dormant. It was sort of impotent. It did not have that much power. It did not cover too much of area. The Supreme Court has interpreted because it narrowly because of several reasons which are mentioned in the judgment A.K. Gopalan in 1950 versus State of Madras. This was the case. So you have the fundamental right of life and liberty, and state shall protect your life and liberty. It can take your life and liberty only according to the procedure established by law. Now, this is an important term. What is procedure established by law? Procedure established by law. A state means the administration, parliament, they can snatch your life. They can send you to the gallows. फांसी लगा सकते हैं, जेल में डाल सकते हैं, कुछ भी कर सकते हैं, बट जो भी वो करेंगे हैज टू बी according to the procedure which is established by the law. That simply means parliament makes law. And if you are trying to take away somebody's life, and if you are trying to take away somebody's liberty, it has to be according to that law. So you have to maintain, it is a sort of constitutionalism where it puts the limit on the power or the arbitrary power of the government, that if a law has been decided, you cannot go out of these four corners of that law, and you have whatever procedure has been mentioned in this law needs to be followed when you are taking away somebody's life and liberty. If let's say there's a person who has been responsible for mass murders and heinous crimes such as rapes and murders, women have been raped and then have been burnt, sometimes alive. These heinous crimes, sometimes the law has to come in and give them punishment of the highest order, the death penalty. That means the state is taking away your life. If they are giving you a sentence of life imprisonment, they are taking away your liberty. What happens in that scenario? That you are deprived of your life and personal liberty. And when you are deprived of your life and personal liberty, how can it be done? Can it be done in an arbitrary manner? That if you are from the opposition party and the sitting party does not like you, so they can stuff you inside a jail and then can take your life? No, they cannot do it, but only if the law permits, and the law is made by the parliament. So they are giving overarching power to the parliament. This is how Article 21 was interpreted, that Parliament has all the power to make any law, whether it be arbitrary. Now, if this law is made and if this turns out to be arbitrary, non-reasonable or unreasonable, this law is arbitrary, this law is unreasonable, will it be allowed? Yes, this is allowed. It was left to the wisdom of the parliament of that time which law to be arbitrary, which law to be reasonable, and it was decided by the parliament through its wisdom whether to call a law or to make a law non-arbitrary and reasonable. But if it turns out to be arbitrary and reasonable, Supreme Court will not interfere. And if it is taking away the life and liberty of an individual, again Supreme Court will not interfere. Why? Because it is mentioned in the law that the life and liberty can only be taken away according to the procedures established by law, and this law is itself saying nothing but pointing towards the procedure which has been established. What is this procedure? It simply means that if you have committed a crime, then there has to be a procedure of punishing you, of convicting you. One of the thing is the police will come and investigate, it will issue a notice to you, then you have to reply, there will be a free trial if you are taken to the magistrate, and if you are taken in conviction, then you have to be produced in front of a magistrate within 24 hours. All these things are procedure, and if this procedure is arbitrary or unreasonable, even that is allowed. That was the amount of power given to the parliament as far as Article 21 goes. Now look at Article 19. Article 19 clause 1 subclause from A to from G. They mention right to freedom. Right to freedom has to be given on several grounds, such as right to freedom of speech and expression, of assembly, of association, of movement, of residence, and choosing your profession. These are several grounds on which freedom has been mentioned under Article 19. Now what ends up happening? If you see Article 19 clause number 2, it puts reasonable restrictions. The restrictions has to be reasonable. If the state is taking away your fundamental right of freedom of speech and expression, it cannot go beyond Article 19 clause number 2. And what is mentioned in Article 19 clause number 2? Several restrictions such as the sovereignty of the country, public order, unity and integrity of the nation, morality and decency, contempt of the court. These are several restrictions which can be applied to limit your freedom of speech and expression. So they are reasonable limitations. These are reasonable restrictions, but no reasonable restrictions was applied under Article 21. Under Article 21, Parliament can make any law as it pleases. Doesn't matter whether it is arbitrary, doesn't matter whether it is unreasonable or illogical. It can make a law, and if your life and your liberty is taken away, and if it is taken away according to the procedure established by law, then nothing can be done. That simply means that the reasonable restrictions which are applied under Article 19 will not be applied under Article 21. This is how you say that Article 19 is exclusive of Article 21 and they are mutually independent, that one article does not depend on the other article. Now if you see, let's take an example. If you have been barred and if you have been taken into custody, what is happening? Under Article 19 clause 1 D, it gives you the freedom of movement. Freedom of movement. You can move throughout the territory of India. Wherever you want to go, you can go. And several reasonable restrictions has been put on the freedom of movement under Article 19 clause number 5. That simply means you can go wherever you want. But if your movement hurts the unity and sovereignty of the country, if your movement is against the public decency and morality, and if your movement is against the law and order, public safety, then your movement can be restricted. Those are the reasonable restrictions. Those are mentioned under Article 19 clause number 5. So one of the argument in A.K. Gopalan case was, under Article 19 you have the right to movement. Under Article 21 you have the right to life and liberty, and your life and liberty can be taken away by any procedure which is established by the law. Now that procedure which is established by the law has to be reasonable, just like Article 19 clause number 5. That means they were making a contention in front of the Supreme Court that the reasonable restrictions which are applied under Article 19 clause 5 shall also be applied to Article 21, because in a way Article 19, which gives the freedom of movement, and Article 21, which gives the liberty, are same. If you have been taken into custody, if the government is taking away your life and your liberty, it is hurting or infringing your fundamental right of movement also. So this is Article 19 and this is Article 21, and here lies your freedom of movement. They cannot be mutually exclusive, they are overlapping. So under Article 19 you have reasonable restrictions, but under Article 21 you do not have reasonable restrictions. आर्टिकल 21 के अंदर पार्लियामेंट जो लॉ बनाएगी उसके हिसाब से आपको चलना पड़ेगा, भले ही वो लॉ आर्बिटरी है. बट आर्टिकल 19 के अंदर पार्लियामेंट ऐसे आर्बिटरी लॉ नहीं बना सकती, ना ही कोई एडमिनिस्ट्रेशन का व्यक्ति या फिर एडमिनिस्ट्रेशन इटसेल्फ आपके राइट टू मूवमेंट को हर्ट कर सकता है अनटिल एंड अनलेस रीजनेबल रिस्ट्रिक्शंस के अंदर में ना आ रहा हो. तो आप देख रहे हैं, दिस वाज द डिफरेंशिएशन in the interpretation of Article 21 from 1951 A.K. Gopalan case came up till 1977 when द स्टांस चेंज्ड इन मेनका गांधी केस। तो अब प्रोसीजर एस्टेब्लिश्ड बाय लॉ को अगर अपन देखें ध्यान से, सो व्हाट इज दिस? एज वी हैव ऑलरेडी टोल्ड, इफ दिस इज द लॉ and we are not going to go into the arbitrariness aspect of it, whether it is arbitrary or non-arbitrary. We are not going to see whether this is reasonable or non-reasonable. What we are concerned about is whether the administration is following the procedure or not. एक बार जो प्रोसीजर बना दिया है वो कैसा भी हो, उसके अकॉर्डिंग अगर आपकी लाइफ और आपकी लिबर्टी ले ली जाती है तो चलेगा। एक दूसरा टर्म आता है प्रोसीजर एस्टेब्लिश्ड बाय लॉ, ये इंडिया में प्रिवेलेंट है, लॉ में लिखा भी है। एक दूसरा टर्म आता है ड्यू प्रोसेस, प्रोसीजरल ड्यू प्रोसेस। दिस इज द प्रैक्टिस which was established under the Constitution of the United States. What is due? Due diligence, due respect. This word is often used. Due. What does due means? Due means just, proper, justified. And when it says procedural due process, that simply means that the procedure which has been established by the law must be just, must be proper, must be justified, must be reasonable. तो यूएस में कोई कॉन्स्टिट्यूशन के अंडर में जब भी किसी लॉ का इंटरप्रिटेशन होता है तो वो दोनों चीजें देखते हैं कि पार्लियामेंट ने एक लॉ बनाया तो उसका प्रोसीजर रीजनेबल है या नहीं। दूसरी चीज, प्रोसीजर्स के थ्रू जो भी एक्शंस लिए जा रहे हैं वो अकॉर्डिंग टू द प्रोसीजर लिए जा रहे हैं या नहीं। एट द सेम टाइम द सब्सटेंस ऑल्सो, कुछ भी लॉ नहीं बनाएंगे, द लॉ हैज टू बी रीजनेबल। तो ड्यू प्रोसेस हैज टू कंपोनेंट, वन इज सब्सटेंटिव, अनदर इज प्रोसीजरल। सब्सटेंटिव एंड प्रोसीजरल। दैट मीन्स लॉ का सब्सटेंस क्या है भाई? आप लॉ में कुछ भी नहीं लिख दोगे ना कि आपने अगर रोड पे थूका तो आपको फांसी हो जाएगी, ये सब्सटेंस है। ये तो प्रोपोर्शनैलिटी के कॉन्सेप्ट के खिलाफ है। आपने रोड पे अगर गुटखा थूक दिया तो कोई हीनियस क्राइम कर दिया क्या? आप पे जुर्माना लग सकता है। आपने रोड गंदी कर दी, ये डिसेंसी के खिलाफ है, बट इसका मतलब ये नहीं पकड़ के आपकी चमड़ी उधड़वा दी जाए। अभी अपन मेडिवल लॉ में नहीं रह रहे हैं, अपन मेडिवल टाइम में नहीं है, अलाउद्दीन खिलजी नहीं है अपन के। 500 ग्राम अगर आपने सामान कम दिया तो व्यापारी का 500 ग्राम मांस निकाल दिया, ये वाला लॉ नहीं है। सिविलाइज्ड सोसाइटी के अंदर कॉन्स्टिट्यूशन के कुछ प्रोविजंस हैं, उनके अंडर में अपन रह रहे हैं और संविधान चल रहा है, देश चल रहा है। तो जो लॉ आप बनाओगे वो भी रीजनेबल होना चाहिए, प्रोपोर्शनल होना चाहिए, जस्टिफाइड होना चाहिए, प्रॉपर होना चाहिए। अगर वो नहीं है तो कोर्ट बीच में कूदेगा और उसको रीजनेबल बनाएगा, क्योंकि कहीं ना कहीं वो कॉन्स्टिट्यूशन के प्रोविजंस के साथ अलाइंड नहीं है। और सुप्रीम कोर्ट का काम ही है, इट इज द प्रोटेक्टर ऑफ द फंडामेंटल राइट ऑफ द सिटीजंस, and it keeps all the law made by the parliament and all the decisions taken by the administration aligned with the provisions of the constitution, especially the fundamental rights. So due process में क्या होता है? substantive, जो substance है law का वो भी reasonable होना चाहिए और जो procedure है वो भी reasonable होना चाहिए। इंडिया में पहले ये कॉन्सेप्ट अंडर आर्टिकल 21 लागू नहीं होता था। ए के गोपालन में तो यहां तक कह दिया कि नेचुरल जस्टिस बड़ा वेग टर्म है एंड वी आर नॉट गोइंग टू फॉलो द नेचुरल जस्टिस क्लॉज अंडर आर्टिकल 21। बट नेचुरल जस्टिस क्लॉज एक बहुत नेचुरल पार्ट है ड्यू प्रोसेस ऑफ लॉ का। नेचुरल जस्टिस इज अ वेरी natural part of due process of law. And what is naturalness in law? That whatever you make, either substance or the procedure, both have to be reasonable, just and proper. And for that reason, in the later on case, which is the Menka Gandhi case, it was interpreted in another way. Now we are going to look what happened in the Menka Gandhi case in the next class. Till here we are going to see what is the link between Article 19, Article 21 and Article 22. Article 22 speaks about preventive detention. This preventive detention clause was challenged in A.K. Gopalan case, A.K. Gopalan versus State of Madras case. And it was contention was made that if you are arresting someone on the charges of preventive detention, what is preventive detention? एक punitive detention होता है, एक preventive detention होता है. Punitive detention is when you have committed a crime and then you have been convicted and you are in jail. This is punitive detention. आपने किसी को छुरा मार दिया, 7 साल का जेल हो गया आपको. Preventive detention क्या होता है? It may not necessarily be that you have done something and because of that you are in jail, or you have been in house arrest, or you have been तड़ी पार कर दिया है शहर से बाहर, you've been sent out of the city. It depends. Preventive detention depends on your past record. You may not have committed any crime, you may not have gone to jail, you have not been convicted, but in this particular given situation, if you can create or you have the tendency to create public disorder, you can be sent to jail for maintenance of the public order. कई बार ऐसा होता है, कुछ केस आ रहा है, फॉर एग्जाम्पल राम मंदिर वाला जजमेंट आया और उस समय कोई भड़काऊ भाषण देकर पब्लिक ऑर्डर को पब्लिक ऑर्डर में हलचल मचा सकता है या फिर डिस्टर्ब कर सकता है पब्लिक ऑर्डर को, तो ऐसे व्यक्ति को उठाकर पुलिस पहले ही जेल में डाल देती है, उन्होंने कुछ नहीं करा हो, क्योंकि अगर ये व्यक्ति बाहर रहे तो इनकी वजह से पब्लिक में फूट पड़ सकती है, तो इनको अभी मामला संवेदनशील है, इनको उठाओ और जेल में डालो. दिस इज कॉल्ड प्रिवेंटिव डिटेंशन. So preventive detention was challenged in A.K. Gopalan case, which is mentioned in Article 22 also. If you see clause 3 and 4, it mentions that state for maintaining the public order can put somebody under preventive detention. और उसमें भी कुछ protections दिए हुए हैं. So this was challenged that the procedure which is established for preventive detention has to be reasonable. But the Supreme Court in A.K. Gopalan case said what? No, it will not be. It will only be procedure established according to the law. Means whatever procedure for preventive detention the parliament is bringing, that is final, even if it is arbitrary or unreasonable. And this position of the Supreme Court starting from 1950 continued till 1977, when in 1978 the Menka Gandhi case has overturned this judgment and the position taken by Supreme Court. तो आर्टिकल 19 के अंदर कुछ ग्राउंड्स दिए हुए हैं जिसमें आपको फ्रीडम मिलता है. यू हैव द फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, ऑफ असेंबली, ऑफ एसोसिएशन, ऑफ रेसिडेंस, ऑफ मूवमेंट, ऑफ प्रोफेशन. बट इसका मतलब ये नहीं है ना कि इन ग्राउंड्स के अलावा कोई और फ्रीडम होती ही नहीं है. क्यों नहीं होती है? You are a free man, I am a free man, somebody can be a free woman, and you can enjoy the freedom of speech and expression, of movement, of association, of assembly, of profession. But what about a person who has been on a trial? What about his rights? Or a person inside the jail, what about his right? Or a person who have been booked under preventive detention, what about his rights? Those are not mentioned in Article 19. Those are covered under Article 21. But उस पे रीजनेबल रिस्ट्रिक्शन का क्लॉज नहीं था, ड्यू प्रोसेस नहीं थी. क्या था? पार्लियामेंट ने जो कर दिया वो माना जाएगा, वैसा का वैसा. इफ इट इज प्रोसीजर विच इज एस्टेब्लिश्ड बाय द लॉ, देन इट विल बी एक्सेप्टेड. डज नॉट मैटर वेदर इट इज आर्बिट्ररी और रीजनेबल, बट इट वॉज देन ओवरटर्न्ड. सो आई होप यू अंडरस्टूड the link between Article 19, 21 and 22. Preventive detention was challenged. You have the life and personal liberty under Article 21. So preventive detention in one or the other way infringes with Article 21. So the contention was made in front of the Supreme Court that if a person has been booked under preventive detention, you are also taking away his right of movement under Article 19. If you are taking away his right under Article 19, then reasonable restrictions are provided under Article 19. Those restrictions which can take away your fundamental right of movement, those restrictions are reasonable. So why don't you apply the same to Article 21 also? Supreme Court said that Article 19 is mutually exclusive of Article 21, and the reasonable restrictions under Article 19 will not be applied under Article 21, and hence the preventive detention will be according to the procedure established by law, not according to the due process. But then came in 1978 the Maneka Gandhi judgment, and it has included due process in the Indian Constitution in Article 21, and from there on Article 21 has been interpreted using both the jurisprudence principles, the procedure established by law, as well as the due process of law. And the due process has to be followed in substantive law and as in procedural law as well. Means when you are making the procedure, it has to be just, proper and reasonable, and the substance of the law has to be just, proper and reasonable. And that is the reason an article which was impotent, an article which was lying dormant in the Constitution, right to life and personal liberty, which only give protection to protection from the administrative decisions at that point in time, also started to give protection from parliamentary actions, from the law-making body of the country, from the lawmakers also, from the government also. Your life and liberty will be protected by the court if the law is not reasonable, just or proper. That change was made when in Maneka Gandhi case the interpretation of the law was changed. I hope you understood this. Next we are going to take the Maneka Gandhi case and how the relation between Article 19, Article 21 and Article 22 changed after that decision, and how they all also included Article 14, and those articles which were seen as islands, different islands, were now linked, were made mutually dependent on each other, not independent. I hope you understood. I hope you will join me in the next class to understand Article 21 better, and also the Maneka Gandhi judgment and its repercussion on the Indian way of life. Thank you very much.